Welcome back to the Deep Dive. Today, we're going to give you a bit of a shortcut, really digging into the legal nuts and bolts of a really powerful government watchdog, the Ombudsman Commission.
That's right. We're focusing squarely on its foundational law, the organic law on the Ombudsman Commission. And like you said, this isn't just standard legislation, it's a provisional organic law.
Okay, so what does that mean practically?
Well, it means it's specifically designed to implement a whole division of the Constitution. Think of it like the direct legal code translating constitutional principles into an actual functioning body. It's serious stuff.
And that organic law status is important for you, the listener, to get. It generally carries more weight than a regular act of parliament, right? Giving the commission some pretty strong insulated powers.
Exactly. Although, interestingly, Section 1 does mention that some parts definitions, a few operational bits, actually take effect as a normal act, so it's a kind of hybrid, really.
A functional hybrid.
Yeah.
But the core idea is independence, built right into the legal framework.
Absolutely. That careful structure is all about ensuring independence. So maybe we should start with who it covers and who actually gets to be on the commission.
Good idea. Let's look at the scope first. The law defines key terms, but the one you really need to understand is the responsible person. This definition basically casts the net for who the commission can investigate.
And it's a wide net. It covers the head of any state department, any provincial body, the boss of any statutory authority, the chair of a local government council.
Okay, so all the usual institutional heads.
Yes, but crucially, it also includes a natural person. That means it's not just about institutions. The commission can focus on the actions of a specific individual within those bodies. It gets personal.
Right, so who gets to wield this power? Because the law sounds like it demands a really high bar for integrity and skills.
Oh, it's intense. Section 4 lays it out. The appointments committee has to believe the candidate has, and I quote, integrity, independence of mind, resolution, and high standing in the community.
Those are pretty demanding kind of subjective criteria.
They are designed, to filter out anyone who might bend to political pressure. But it's not just about character.
No. What else?
There are specific professional requirements. And this tells you a lot about what they expect the commission to tackle.
Okay, like what?
Well, one ombudsman must have professional accountancy qualifications and experience. Think forensic accounting.
Following the money.
Exactly. And the other needs administrative or legal qualifications and experience. So you've got financial expertise paired with legal or administrative know-how.
That's a powerful combination.
Yep.
Like financial detectives and legal eagles rolled into one.
Pretty much. It suggests they're geared up to handle complex financial mismanagement and administrative or legal breaches.
And this expertise is backed by strict rules about how long they serve and how they're protected.
Right.
To keep them independent.
Yes, look at the terms. For citizens, it's a maximum of 6 years with possible reappointment, but there's a hard limit. You're out if you hit 75 or if you've already served 2 terms, so no jobs for life. It ensures some turnover.
Prevents entrenchment. And what about financial independence? That seems key.
Absolutely key. Section 10, subsection 3 is fascinating. It says members get a lifetime pension when they leave office unless they were actually fired.
Wow, a lifetime pension. That's a strong incentive to stay clean during your term, isn't it?
Yeah.
Your financial future is secured afterwards.
Precisely. It removes a potential vulnerability. And this financial security complements the strict political firewalls.
What are those?
Well, a commissioner can't be an MP or involved in provincial or local government. They can't hold office in a political party either.
Okay, so a clear separation from active politics.
And Section 8 goes further. They must not actively engage in politics at all. Plus, there are tight restrictions on them managing or controlling businesses for profit.
So, keeping their financial and political interests totally separate from the areas they might investigate.
Exactly. It's all about that independence. So we've got these highly qualified independent people. Now, what about their actual powers? What can they do?
Right, the legal hammer, as you called it earlier. Section 13 seems pretty broad.
It is. The commission can investigate conduct based on a complaint from someone affected, sure. But, and this is really important, it can also investigate on its own initiative.
Meaning they don't have to wait for someone to blow the whistle. If they smell something fishy, they can just launch an investigation.
That's exactly it. Into any state service, any government body, any officer or employee. It's a proactive power.
And making a complaint seems quite accessible. Section 16 says anyone can do it.
Mm-hmm.
But there's a really specific point in there about people in custody, isn't there?
Yes, this is quite remarkable, actually. It's about protecting communication. A letter sent to the commission by someone in prison or, confined in any government
Yeah.
institution
Yeah.
cannot be opened by anyone except a member of the commission or someone they authorize.
And there are penalties for breaking that rule.
There are. A hefty fine, K-1000, or 12 months in jail if someone interferes with that confidential mail.
That level of specific protection for prisoners' letters really speaks volumes, doesn't it, about ensuring access for potentially very vulnerable people.
It really does. It suggests a strong intent to hear from those who might be most susceptible to administrative abuse or neglect.
But the commission isn't obligated to investigate everything that lands on its desk, is it? There's some discretion involved.
Yes, and that's crucial for managing their workload and focusing their impact. The law calls it deliberate judgment. They can decide not to investigate or to stop an investigation.
On what grounds?
Well, if the complaint is trivial or, just meant to cause trouble, frivolous or vexatious is the legal term. But also, importantly, if the person complaining has another reasonable option, like going to court or using an internal complaint system.
So they don't duplicate effort.
Right. Or if the complaint is just too old. And interestingly, they can also decline if they simply have other matters more worthy of its attention or, frankly, if they don't have the resources.
Practical considerations. So let's say they do decide to investigate. How does that proceed? Section 17 talks about the conduct.
Okay, so first, fairness. They have to tell the responsible person, the head of the agency, or the individual involved that they intend to investigate.
Give them a heads up.
Yes, and generally, these investigations happen in private. That's to protect reputations while things are still being looked into.
But there's an exception to that privacy rule.
A big one. If the commission believes it's uncovering potential criminal conduct, it can decide, using its deliberate judgment again, to conduct the investigation publicly.
Right, that makes sense. Now, the power to get information, Section 18, this sounds like where the real teeth are.
It absolutely is. They can require any person, not just government officials, literally anyone, to provide information, documents, whatever they need for the investigation.
Any person. That's incredibly broad.
It is, and they can summon people to be questioned under oath.
So, compel testimony. What about protecting those witnesses? If they reveal wrongdoing, are they exposed?
Ugh. This is where it gets legally very interesting. Witnesses have the same privileges as they would in the national court. But here's the crucial part.
Yeah.
Except if they're later tried for perjury, for lying under oath to the commission, nothing they say, no statement or answer they give during the Ombudsman investigation can be used as evidence against them in any other court case or legal proceeding.
Wow. So it's almost like a form of limited immunity, isn't it?
Yeah.
To encourage people to talk freely about potentially dodgy stuff without fear of immediate self-incrimination in some other trial.
That's a really good way to put it. It seems designed to get the information needed to fix systemic problems, even if it means shielding the witness from collateral prosecution based solely on what they tell the commission. The focus is on the bigger picture of administrative or governmental conduct.
That's a huge power. But is it unlimited? Is there anything the commission can't demand?
Yes. And this is where we hit Section 19. It's the ultimate check, the point where the executive branch can draw a line.
The prime minister's role.
Exactly. If the prime minister, after consulting with the commission, so there's a discussion, certifies that providing certain information or answering a specific question would harm national security, defense, international relations.
Okay, the big stuff.
Yes, or if it would reveal confidential discussions of the National Executive Council, basically the cabinet.
Then what happens?
Then the commission shall not require that information to be disclosed. Full stop. The PM's certification in those specific high-stakes areas overrides the commission's power to compel.
So the law itself builds in this tension between the watchdog's need to know and the executive's need for secrecy in certain core functions.
Precisely. It's a codified balancing act. And there's a similar, though maybe more day-to-day limit in Section 36 regarding entering premises.
Oh yeah, the power of entry.
Right. A commissioner can enter premises occupied by a state body they have jurisdiction over to inspect things. They have to notify the head first. But again, the prime minister can block this power if there are security concerns about that specific location.
Okay, so the investigation happens, they gather evidence, maybe they hit that Section 19 wall, maybe not. What happens at the end if they find something wrong? Section 22.
Right. If the commission concludes the conduct was wrong, or a law or practice is defective or maybe discriminatory, they report their findings and recommendations.
Who do they report to?
to the responsible minister and the permanent head or statutory head involved.
And then, is it just a report that gathers dust?
No, this is key. There's a mandatory response requirement. The minister or head must tell the commission within a set time frame what steps, if any, they plan to take based on the recommendations.
Ah, so they have to go on record about whether they're going to act on it. Accountability.
Exactly. It forces engagement. And if the finding is about actual misconduct or a breach of duty by an individual, the commission refers it to their boss, the relevant head, sends a copy to the minister, and importantly, may also refer the whole matter to the public prosecutor if it looks like a crime might have been committed.
So it can lead to disciplinary action or even criminal charges down the line. Is this stuff made public?
Section 23 gives the commission the discretion to publish its findings. If they do, copies go to the Prime Minister, the Chief Justice, the Speaker of Parliament who has to table it in Parliament, and others. So, yes, potential for public exposure.
Okay, now let's talk about something that sounds incredibly significant. Section 24, non-reviewability. What on earth does that mean?
It's huge. This is probably one of the most potent aspects of the commission's legal standing.
It sounds like it means their decisions can't be challenged in court.
That's basically it. The law states very clearly, no proceeding or decision of the commission can be challenged, reviewed, quashed, or called into question in any court.
Seriously? No appeal.
Well, there's one tiny exception. You can challenge a decision, but only on the ground of lack of jurisdiction. Meaning, the only way to fight it in court is to argue that the commission never had the legal authority to investigate that particular matter or body in the first place. You can't argue about the substance of their findings or recommendations, just whether they overstepped their boundaries.
That gives the commission an almost judge-like finality within its specific area, doesn't it?
It absolutely does. It elevates their decisions above the normal judicial review process for most practical purposes. It's a massive shield protecting their independence and finality.
And to make sure people take the commission seriously during investigations, there are actual penalties for obstructing them. Part 7.
Yes, the law has teeth. Failing to show up when summoned or refusing to produce documents, that's a K-2500 fine. Contempt of the commission, disrespecting it, obstructing it carries the same fine or 6 months in prison.
And lying to them.
Treated as perjury, same as lying in court.
So, real consequences. And finally, what about protection for the commissioners and their staff themselves? Section 35.
Right, immunity. Members, officers, employees, they're not liable for anything they do as part of their job, as long as it's done in good faith and without negligence.
So protection from lawsuits related to their investigations.
Yes. And, crucially, they cannot be forced to testify in court about information they obtained while doing their job for the commission. This further protects the confidentiality and integrity of their work.
Okay, so if we take a step back now, look at this whole legal blueprint.
Yeah.
What are the really crucial takeaways for you, the listener?
I think there are a few big ones. First, the very specific structure requiring that blend of accountancy and legal admin skills. It tells you this body is built for forensic investigation into potentially complex issues.
Right, the skills match the mission.
Second, that inherent tension we discussed. You have this incredibly broad power for the commission to demand information from anyone, backed by witness protection. But then you have that clear limit, the executive's power via the Prime Minister's certificate to withhold information related to national security or core cabinet functions. That balance is hardwired into law.
And the independence is reinforced everywhere, isn't it? The appointment rules, the fixed terms, the lifetime pension, the disqualifications.
And especially that non-reviewability clause in Section 24, that judicial insulation is perhaps the strongest guarantee of its power and autonomy.
Which brings us to a final thought. Something for you to mull over. Section 24 makes commission decisions virtually unchallengeable in court. Right.
Except on jurisdiction.
But then Section 38, which is a savings clause, says that this organic law doesn't affect other remedies or rights of appeal that might exist under other laws.
Interesting point.
So you have the Ombudsman's decision being basically final. But the law also acknowledges you might have other options, like maybe suing through the regular courts under a different law. Given the Ombudsman route offers this near finality, how does knowing those other remedies still exist influence your choice as a citizen? Do you go to the commission hoping for a definitive administrative ruling, or do you take your chances with potentially slower but perhaps different outcomes in the traditional court system?
That's a really practical dilemma, isn't it? Choosing the right path depends entirely on understanding the specific powers, the speed, the finality, and also the limitations of the Ombudsman Commission, as laid out in this very law we've just unpacked.
It really forces a strategic decision right at the start. Well, that's all we have time for on this deep dive. Thanks for joining us.
Until next time.